My name is Yalçınkaya. Welcome to this broadcast. Today we are going to be discussing European Court of Human Rights, Yalçınkaya decision with Professor Ireneusz Kamiński. And we'll be asking him questions as to why this decision is pivotal and how Turkey exactly violated the European Convention on Human Rights. Professor Kamiński, welcome.
My pleasure.
Yeah. Before we start, for those who do not already know you, can I kindly ask you to introduce yourself to our audience?
Very briefly, I graduated in law and sociology, studying both in Poland and in Brussels. Currently, I work as law professor at Polish Academy of Sciences, Institute for Law Studies in Warsaw, and also I lecture at Jagiellonian University in Krakow, which is the oldest university in Poland. I deal with public international law, first of all, human rights law. So I am a specialist in European Convention on Human Rights. I cooperated with a number of non-governmental organizations in Poland, for example, Helsinki Foundation on Human Rights, and also with other organizations, international organizations. For 2 years, between 2014 and 2016, I was an ad hoc judge at the European Court of Human Rights, or a substitute judge at that court. I am a practicing lawyer representing a number of individuals before the European Court of Human Rights and also before other international human rights bodies.
Thank you. And if we regarding Yalçınkaya decision, as a former judge of the court, why do you think this decision is a pivotal one?
This decision is very important because it's not a single case, that's not a separate violation of human rights that happened to Mr. Yalçınkaya. But, this case is representative for or illustrative of a huge number of repeating violation of human rights. So this case is, in illustration of a systemic problem with human rights application in Turkey or Turkey. It means, that there must be a policy of implementing this judgment in order to meet the human rights standard applicable in this case. To give some numbers, similar cases to that of Mr. Yalçınkaya are pending at the court. And the number of such cases is around 8,000. So that's a huge number of cases currently being considered by the European Court of Human Rights. And even what is more important, around 1,100 similar cases are pending at different level in Turkish courts. So it means estimates say that as many as 2 million are repeated. 2 million people in Turkey are possibly affected by the kind of violation that had happened in the case of Mr. Yalçınkaya. So that's a huge problem that is present in a law application process, and first of all, of course, also in legislation applicable to similar cases in Turkey.
Yeah. And the decision, the Yalçınkaya decision, seems to evolve around a messaging app which is called Bylock, and Turkey's using it as unlawful evidence. And what exactly Bylock is, and how exactly Turkey violate the convention with regards to its handling of Bylock app as evidence of terrorist activity?
Yeah, Bylock is an encrypted messaging application broadly and freely available to, a number of people. So that was available. I don't know whether it's still available, but it was available on different software stores, for example, Google Play, and people made use of this application very, very broadly. So it was popular, especially in Turkey, but I consider, as far as I know, also in other countries. So that was a simple encrypted software used broadly by many individuals. Uh, you know, we have also other similar software messaging applications, for example, WhatsApp. So it's nothing, criminal in having such application on your cell phone. But anyway, Turkish authorities considered having downloaded this application as sufficient evidence that person having such application must have been involved in some illegal activities considered very, very serious for the public order. In other words, if a person had this application downloaded on his or her cell phone, this person was considered to be involved in illegal activities, considered detrimental to public order in Turkey. Even more, these illegal activities were considered to be of armed terrorist character. So it made possible to qualify such, activities, or more, or merely having this application downloaded as being a part of terrorist cells. And it resulted in, a huge number of cases under Turkish Penal Code, more specifically, Article 314, paragraph 2, starting against a number of individuals. So it resulted in very severe persecutions and judgments rendered against a huge number of people. So Mr. Yalçınkaya is only one of such person affected by, this legislation and more precisely by its application, very, very, automatic application. If a person, I repeat it, has this application downloaded, it means that this person must have been involved in illegal terrorist, I stress it, terrorist activities, armed terrorist groups. So that had, very serious consequences for a number of people.
Thank you. And of course, the court found that Turkey also violated the legal principle of punishment, no punishment without law. And how did Turkey exactly violated this particular article?
Punishment without law is one of the fundamental guarantees of human rights character. It means that, you know, this guarantee is ranked very high as human rights guarantees, human rights. It is necessary for human rights protection, and if you look at the decisions of the European Court of Human Rights, Article 7, which is on punishment without law, and precisely prohibition of punishment without law, is ranked as one of key guarantees necessary to meet the convention, the most important convention human rights standards. So that's not a simple guarantee. That's one of the key and most important human rights guarantees under the European Convention of Human Rights. And to explain what Article 7 is about, it prohibits punishment without a national legislation. That's first consequence of Article 7. Also, this legislation must be formulated with a sufficient degree of precision. It means that, you know, such a legislation must not be vague, overbroad. It must be clear to possible to people who may be prosecuted under national legislation, to know what is prohibited and what penalties are provided for under national legislation. Third, you know, the law application of this legislation, penal legislation, criminal legislation, must not be arbitrary. So there is a number of specific guarantees stemming from Article 7 on the prohibition of punishment without law. And, you know, this very important guarantee of human rights standards under the European Convention of Human Rights have been violated in Yalçınkaya case. Why did it happen? For a number of reasons. But first of all, Article 314, paragraph 1, so the provision on the prohibition of terrorist activities, have been applied very, very broadly in Mr. Yalçınkaya case. The National Court considered that what I mentioned before, having Bylock application is sufficient evidence of being a part of armed terrorist organizations. So no other elements of the offense were necessary to meet the standard of that exist under Turkish penal law legislation. It's so sufficient that Mr. Yalçınkaya had downloaded this application to go to the conclusion that he must have been part of terrorist armed activities, organization, and it resulted in sentencing him to 6 years, 3 months of imprisonment. So this penalty was very, very harsh. And the European Court of Human Rights concluded that the automatic application of the Turkish legislation, or in other terms, relying on one simple piece of evidence, without any other elements necessary, both, as we lawyers say, of objective character, so some types of activities which are demonstrative of terrorist activities, and also subjective elements, so a kind of guilty necessary for this crime. So simply by downloading this application, it was sufficient to national court to conclude that Mr. Yalçınkaya must have been a member of terrorist cells.
The court found that not only the domestic laws were designed in such a way that it infringed, violated the principle of no punishment without law, but it also found that the Turkish courts, the domestic courts, application of those laws were also in violation of the applicant's right to a fair trial, and so it found that his right to a fair trial was also violated. Do you agree with the court's conclusion?
I fully agree with this conclusion on Article 6, which guarantees right to a fair trial. Article 6 is very broad, so it offers a number of specific guarantees, but one of them is equality of arms. Equality of arms between two actors of any criminal procedure. On the one side, the prosecution, and on the other side, the accused. So there must be the equality of arms. There must be guarantees of what we lawyers called adversarial procedure. It means that, the two sides, the prosecution and the accused, must be treated equally by the court. Of course, the European Court of Human Rights agrees that, some limitation to access to information, first of all, if information is confidential, are possible, so are compliant with human rights standards, do not violate such limitation, human rights standards. But anyway, any such limitations must be counterbalanced by procedural arrangements. But what happened in Mr. Yalçınkaya case? He was deprived of any counterbalance measures. The Turkish courts in his case relied on the material submitted by the prosecution, and that material was offered by the intelligence agencies, and the Turkish court accepted that such materials are reliable. That's first. Second, the Turkish courts accepted that these materials are fully acceptable for the procedure, and third, that Mr. Yalçınkaya did not have access to such materials, even very, general information on the character of this material, its reliability, and the way it had been qualified as demonstrating his involvement in criminal activities by first the intelligence and second by the courts. So even if some limitations of access to information on evidence are acceptable under the European Convention of Human Rights, there must be counterbalancing measures offered to the accused, which did not happen in the case of Mr. Yalçınkaya. So the court concluded that there was a violation of adversarial procedure and more generally of the equality of arms principle.
Thank you. And the court, of course, pointed out certain systematic issues in relation to conviction based on Turkey's, as you put, broad anti-terror laws. And what sort of systematic problems have you identified?
The European Court of Human Rights pointed to a number of systemic problems. As I have already stressed, the Yalçınkaya case is not a separate, simple violation that happened accidentally or incidentally in Turkey. This case is illustrative of a systemic violation, a repeating violation of human rights standards under the European Convention of Human Rights. So I mentioned a couple of numbers of cases pending both before the European Court of Human Rights and domestically in Turkey. So that's a systematic and large-scale problem of number of violations reappearing in Turkey. First, that's the automatic application of the assumption that the mere possession, the mere downloading of Bylock application suffices to demonstrate that a given person must have been involved in illegal terrorist activities. So this automatic application is in violation of the European Convention of Human Rights and is a large-scale violation of human rights convention principles. Second, the requirement of a fair trial stemming from Article 6 requires changes, profound changes in a Turkish procedure. That's not the problem of legislation, Turkish legislation. That's a problem of its legislation application by Turkish courts. That's a number of changes that are necessary to be implemented in, I stress this again, in Turkish practice, not in legislation, because the European Court of Human Rights accepted that legislation as such meets the standards of the convention. That's the problem of this legislation application, which resulted in large-scale violations of human rights, which the case of Mr. Yalçınkaya is only one of the illustrations.
And finally, what do you think Turkey should be doing in order to fully comply with Yalçınkaya decision?
I think that the lesson offered by the European Court judgment in Yalçınkaya is very clear. First, Turkish authorities must cease to automatically hold the mere use of Bylock application suffices as evidence that a given person is a member of terrorist organizations. So it is necessary to establish making application of the Turkish legislation applicable for such cases, that all constituent elements of the offense under Article 314, paragraph 1, have been met. So that there are both objective and subjective elements present in any case pending before Turkish courts. So that's, only using fully applying Turkish legislation, which is necessary to meet the convention standards. Second, to meet the relevant standards of fair trial under Article 6 of the European Convention of Human Rights, any person accused under Article 314, paragraph 2, must be given the opportunity to challenge the evidence offered by the prosecution and oppose it. So national courts must analyze the reasons for no disclosure of materials to the accused, and the relevant counterbalancing measures must be in place in order to secure the rights to fair trial of any person accused under Turkish legislation. So the lessons, the necessary steps that must be taken in Turkey, I think, have been clearly identified in the judgment we are talking about.
Thank you. Thank you.
Thank you very much.
Today we were with Professor Kamiński, and we discussed the European Court of Human Rights Yalçınkaya decision with him. Professor Kamiński, thank you very much again. And
it was my pleasure. Thank you for your invitation.
thank you. Bye.
Bye.